Hello, I'm Sharon Abaud, immigration attorney, here with you this week for our weekly Ask Sharon episode. Every Tuesday, I am here at 6 p.m. answering your questions live. I'm super excited to be here. I do kindly ask you and remind you to protect your own privacy and not ask me questions that bring out all your personal information. Try to keep questions general and I can answer it that way. I do want to protect your privacy, and I do remind you that this is not the same as a one-on-one consultation, and I will only be able to provide you general information in this forum. And I do hope that I can help many of you this way. This is why I'm here this week and every Tuesday to answer your questions. And for those of you who prefer to watch me in Spanish, I have a Facebook Live every Thursday at 6 p.m. In Spanish. I will keep this one in English and Thursdays are in Spanish. I want to remind you guys to go ahead and like and follow my Facebook page, and that way you receive notifications every time I'm live and you don't miss my next episode for those of you watching the recorded video. And then also subscribe to my YouTube channel. I upload videos there regularly talking about various immigration topics, and a lot of people learn of ways that they qualify through those videos that they didn't know before. So it's really great that you educate yourselves and that you explore your opportunities through these avenues that I provide, both in my YouTube video and here on Facebook Live. I'm super excited to be here to answer your questions live. And I am waiting for, and I'm actually going to test the comment right now because I'm using a new platform. And okay, it is working. So what I'm going to do, we're going to start out with our regular with the questions that I received last week in the recorded video and weeks prior. And then as I get questions, as more of you come in and ask me your questions, I will certainly answer them for you as best as I can. I see Michelle is here. Hello, Michelle. Thank you for being here again. So these are, let's see. And for those of you tuning in, I want to remind you to go ahead and like and follow my Facebook page so that you're always in tune with when I'm live. And I also want to remind you that if you do want to set up a one-on-one consultation with me, you can call 310-803-3040. You can also go to my website and you can schedule an appointment there. It's super easy. And Michelle's asking me a question. She's asking, do you know if they're already canceled the I-864 because I want to file? The I-864 is the affidavit of support that you file for a sponsor. So is that what you're talking about, Michelle? That you want to sponsor someone, you want to know if that's still necessary? If that's the case, then yes, it's still a requirement. It's true that it used to be that the I-864 proved that a person wasn't a public charge because it showed that there was a citizen willing to cover for them in case the immigrant became a public charge. Now, under the new policy, beginning in October, that won't be enough. So it's really, but that doesn't mean that the I-864 is not necessary anymore. The I-864 is definitely still a requirement. If you are petitioning for a family member, you certainly need to include the I-864 along with your most recently filed taxes, W-2s if you're an employee, and a letter from an employer, and perhaps some pay stubs demonstrating your income. This will help prove that you make the income that you state you make on your application and that you qualify to be a sponsor. Same goes, so if you're a petitioner and you don't qualify alone to be a sponsor and so you need a co-sponsor or a joint sponsor, then same thing goes for the joint sponsor. They're going to need to provide their most recently filed taxes, a letter from an employer, W-2s if they're an employee, and their payment stubs. So that's that. But the I-864 is certainly still necessary. I see why, I understand your why you thought that, Michelle, but most certainly, yes, you still need to file the I-864. Good question. And I have here a question. Good morning, attorney. Can a stepdaughter file for a step parent? Yes, most certainly. So a stepdaughter, the key here is that the relationship was created before the stepchild was 18. So if the child turned 18 and then mom and stepdad got married, too late. Daughter can't file for stepdad or stepdad can't file for daughter. If daughter was 17, when at the time they got married, then they qualify. But remember that the person if the daughter is petitioning, she needs to be at least 21, and the marriage of the step parent with the parent needs to have happened before that child was 18. Very good question. Very interesting. I know a lot of you, that's a common, frequent question that I get. Okay, so Michelle's saying, I did not make enough to sponsor my husband, and they told me that I need a sponsor. Yes, so Michelle, if you are the person petitioning for your husband, you need to fill out an I-864 as well, and you need to provide your information. But you need someone to sort of co-sponsor with you, to be with you. So yes, that's definitely a situation where they would file their own I-864 and they're going to present their own evidence showing that they qualify. That means they have to bring in their taxes, W-2s, if they have them, a letter from employer or pay stubs. They're going to want to show their income or assets, whatever they're using. There's various ways to prove that you qualify, not just income. And so you will have to do two of those, one for you and one for the sponsor. Very good question. Another question and I don't have your names written here, so my apologies. I hope that those of you who asked remember it was your question and then I answer it for you. Someone beat me at work. Do you think I could qualify for a U visa? So there's a lot I would need to ask here. This definitely, if you were assaulted or injured by another person intentionally, if there was some sort of crime committed against you, then most certainly you might qualify for a U visa. I would definitely go consult with an immigration attorney and see if it is a qualifying crime. I handle these types of cases, and when I do, I like to look at the police report if we have it, or I like to ask questions about what happened to determine if it would be a qualifying crime. The first step for a U visa would be to obtain a U visa certification from the law enforcement agency. Once I obtain that signature, we have only until 6 months after that form is signed to file the U visa. If we file after that, we lose it. So it's really important that we file the U visa within those 6 months after the U visa certification is filed. And then after that, we file the U visa, and then we wait the processing times, and then until a U visa is available. But it's really important that you consult with an immigration attorney who understands U visas. I also see a possibility. I would want to ask more questions, definitely, of maybe a T visa, because you're saying something happened at work. So I would want to know more there. This definitely sounds like something where an immigration attorney could do a little digging and see if maybe we can help you qualify for some sort of relief. If you would like to schedule an appointment with me, you can call me at 310-803-3040, or you can go to my website, www.aboutlegal.com, and you can schedule an appointment there. I have here, can traffic tickets hurt my immigration case? So like we know, there are many types of immigration cases. I'm guessing this person is talking about a case to get a green card, so they're talking about those rules of inadmissibility. If you have a traffic ticket, generally this is not something that would affect you. Of course, I would want to know more because, when I do a consultation, I always ask for everything. I even want to know about these traffic tickets because sometimes what appears minor to you could not be so minor. Or sometimes what happens often is people sort of ignore these tickets maybe, or forget about it, or put it on the side, and then it becomes something, and it can become a warrant for your arrest, and then that's when we can have a problem. Then I would definitely recommend you go see a criminal attorney to fix that before we proceed. So I do like to know about everything, because I want to know if there is anything that appears small that could be an issue. But generally speaking, traffic tickets that are minor traffic tickets that were paid in time and the case is closed should not present an issue. But I would always mention everything to your attorney, of course, just to make sure there is no problem with the particular case. And Michelle, works in a warehouse, and they told her they can sponsor for her husband. So generally speaking, they want someone who is a U.S. citizen or resident, and there does have to be some familial, some family relationship. So we could have a problem there. If you have a family member that could qualify, that would likely be better. Okay, so, and also I would look into, Michelle, I would look into, I don't know what your situation is, but I always like to see if there's another way that the sponsor, the petitioner spouse could qualify. Because, you know, maybe you have a certain amount, say in savings, or maybe you have you own something that would make you qualify, because, and sometimes the spouse's income can count. So I don't know your husband's situation, but maybe he's in a situation where his own income can count. For example, in many situations where someone worked with DACA, we can make their income count. So I would consult with an immigration attorney for this and see if there's a way that you could qualify without having to ask another sponsor. I always like to explore that possibility before we bring in other people, because there are other ways other than you working at the time to qualify for this. So that's really important information. So I have another question here. I filed for a U visa last year, but still don't have my work permit. Is this normal? So this is always a common question. It didn't used to be like this, really. I mean, only a couple years ago, people would file for a U visa, and they would, not a couple years ago, maybe 4 years ago, people would file for a U visa and get their U visa almost, within a year for sure. And then what happened is, remember that Congress only allows 10,000 U visas to be given out in a year. And so these U visas started getting more and more popular, more in demand. And so two things happened. One thing is that the processing time got really slow. And the other thing is that the U visa wait list became longer and longer. So there's two waiting periods, I like to call it. The first waiting period is when you're waiting for a decision on your case. So let's say we file our U visa today. We're looking at about 4 to 5 years for immigration. Right now they're at 2015, so it's about 4 years. It takes them about that long to decide your case. But when they decide your case, it's actually they're not giving you the U visa because you have to wait in line for it. So what they give you is a conditional approval. Hi, Joanna. Nice to see you here. And so they give you a conditional approval, and only then you qualify for the work permit. So it's not like when you marry a U.S. citizen and you file for adjustment of status and you get your work permit in a couple of months. It's very different. You do have to wait 4.5 to 5 years for your work permit. And then you get your social security number. And then the wait for the U visa right now is a very long wait. About, they're saying right now it's at about 17 years. So that's really long, but you do get your work permit, and it has a lot of people, I mean, it is a very frustrating wait time right now, but it is the only option for a lot of people. And it does waive a lot of issues of inadmissibility. Hi, Adriana, hola. And it does offer a lot of waivers of inadmissibility. So if, for example, this has happened, I've seen this happen many times before. There's someone who came into the U.S. maybe claiming they were U.S. citizen, okay? And what that is a permanent bar to the U.S. That means you can't, even if you, let's say, marry a U.S. citizen, like you can't immigrate that way if you did that. It's a very serious bar, and there's no waiver for it. It's considered very serious under immigration law. However, with the U visa, that's something we could waive. And so there are many reasons why this U visa can still has a lot of benefits despite the long wait time. And so that's my take on it. And you still get your work permit. You know, it is a long wait for the work permit as well, but you do get that as well. And I understand these wait times are very confusing and very crazy, but you can always check. I have a video on this, and I'll link it after this is done. But I made a video especially for the U visa processing times. And it's really shows you how you can check your own case and check the own status and the own progress of what of how long these cases are supposed to take. So really important information there. Hola Wagner, saludos. I have another question here. My wife is a lawful permanent resident and my tourist visa expired. Can I file for adjustment of status? So this is a common question. And if you are married to a U.S. citizen, and the U.S. citizen and the immigrant entered with a tourist visa, and then, you know, he was planning on going back home, but then he got here and he fell in love and he changed his mind. And then they get married, and by the time they get married and file, the person who entered the tourist visa's status already expired. So he doesn't have a status at the time he files. And when he's married to a U.S. citizen, that's not a problem. That's not an issue because that's fine. The problem is when let's say you enter with a tourist visa, you meet a resident. A resident is not considered an immediate relative. Why? Because you're supposed to wait in line for a visa. There's not a visa immediately available to you. So because you have to wait in line, you don't have the same rule as someone married to a U.S. citizen. And so if you file for adjustment of status while at the moment that you don't have status anymore, you don't qualify. You're going to get denied. So the way that you would have to do it, you would have to immigrate. You would have to leave the country to go to your interview and then return. Of course, I always recommend you consult an immigration attorney to understand if there are any other issues and to do everything the right way, because there can be a lot of obstacles that come along the way. And it's always best that you understand what is coming before you present yourself. So that's the difference between marrying a resident and a citizen. And so for this person who asked in this situation, I don't know a lot. I would want to know if they maintain status, if they're maybe they changed their status to a student visa, although they wouldn't be able to as a tourist. But I would, in this situation, I would definitely want to know more, but it sounds like they would have a problem down the line because, you know, when you are married to a lawful permanent resident and your status expires, you are barred from filing for adjustment of status. You have to leave the country to immigrate. Now, this bar doesn't apply if you have 245I, and most people who have 245I know they have 245I. It's for people who have a petition filed on their behalf on April 30th, 2001 or before. It also applies to certain family members. So if you have a family member like a spouse or a parent with 245I, always let your attorney know to see if you might have it too. So really important, 245I would allow you to adjust status no matter how you entered, you know, no matter what your status is right now, because of the protection that was given during that time. Hi, Daniel. Nice to see you again. Okay. And I have another question here. I got a conditional green card through my husband almost 2 years ago. Now it's time to file to lift conditions, but my husband and I are getting a divorce. It's been very hard accepting that our marriage is over and also knowing that I might not be allowed to stay here because we are not together anymore. Is there anything I can do? It's a really great question. A lot of people think that because their marriage is over, that, and they still haven't met the 2 years, that they're just going to have to leave or abandon everything. And that's not the case. So this person filed for residency probably 2 years, within the first 2 years of their marriage. And when you do that, they give you what's called a conditional residency, which means you're a permanent resident. You have most of the same rights as all the other residents, but you have to present yourself here again 90 days before your 2-year anniversary of the green card. And you have to show to us that your marriage is real. And a lot of times, a lot of things can happen in 2 years, right? Marriages sometimes don't work out. And it's really hard on people, especially because, they're going through a difficult break in a relationship. They're, the person they fell in love with, it didn't work out, and that's heartbreaking. And on top of that, this life that they had reestablished here might end because they feel like they're going to have to leave and start over again. So it's really hard. But there is an option for people. If you are in that situation, there is an option for you. If you are in the process of a divorce, you can file for what's called a waiver of the joint filing requirement, so the I-751 waiver, and you have to prove that you are divorced and that your marriage was real at the time that you got married. This can be a little bit difficult for marriages that were very short. But it is certainly possible. There's also another waiver for people who, if you were a victim of abuse or extreme cruelty at the hands of your spouse, there may be an option for you to file this waiver and get your permanent residency that way. And there's also a waiver for people who prove that they would suffer extreme hardship if they had to return to their country. So these are all three viable options. But if you are in the process of getting a divorce, I think the first option I mentioned would be the best one for you. I would certainly do this case with an immigration attorney. It can get a little tricky. And I handle these types of cases all the time. And if you would like to speak with me, I would I would love to speak with you, and my number is 310-803-3040. You can also schedule an appointment online at aboudlegal.com. And we can definitely talk more about your case. There's a lot more I would have to know, but I have certainly won those types of cases before. And it is possible. It is work, but it is certainly possible. And so I don't have a lot of questions here today live. I want to thank you guys for being here and watching. As always, it's really amazing. I'm here on Thursdays in Spanish at 6 p.m. Estoy aquí los jueves a las 6 p.m. en español. And I want to remind you to like and follow my Facebook page so that you receive notification every time I'm here live. And I want you guys to share, please, share, so that you share the information with other people you know and who may benefit from this information. I also want to remind you I have a YouTube channel where you can... Hola, Wagner, le voy a hacer la pregunta en español el jueves. Este video lo hacemos solamente en inglés y los jueves hacemos los videos en español. Pero sí voy a guardar esta pregunta para el jueves. Muchas gracias. But yes, please subscribe to my YouTube channel. There I upload videos regularly, and it's not so much of a Q&A like it is here, but it's more educating you on different topics, and there's always something new you can learn that can benefit for you. So definitely watch those, subscribe to my channel, and share as well. I really, really, really love being here. I appreciate you guys being here. I'm super thankful. Thank you for participating, and I will see you guys next time. Bye.